Good morning, everybody. Welcome back to the Joint Standing Committee on Labor and Housing. It is a bright crystal winter day of Wednesday, February 9th. We've got a bunch of work sessions in front of us. We're going to start with introductions and go from there. I am Maddie Daughtry. I represent State Senate District 24, which includes the communities of Freeport, North Yarmouth, Pownell, Harpswell, and my hometown of Brunswick. I'm going to kick it over to my esteemed House Chair, Mike Sylvester.
Thank you, Madam Chair. I'm Representative Mike Sylvester. I represent District 39, which is the Eastern Peninsula portion of Portland and the Fighting Islands of Casco Bay. And I appreciate everybody being here today. And once again, if everyone can make sure that if you're in the gallery, typically we will call on you and the chair will go through all that. But if you could keep your cameras down and your mute button on, that'd be great. Thank you.
Thank you so much. And Senator Guerin.
Good morning. I'm Senator Stacey Guerin, representing Southern Penobscot County, which is Senate District 10.
And I'm not seeing Senator Hickman with us this morning. So Representative Bradstreet.
Good morning. I'm Representative Dick Bradstreet from House District 80, and that's comprised of Vassalboro, Windsor, Somerville, and part of Augusta.
Thank you. Representative Cuddy.
Good morning. My name is Scott Cuddy. I represent House District 98, which is Winterport, Frankfort, Searsport, and Swanville, and I live in Winterport.
Representative Drinkwater.
Yes, I'm Representative Gary Drinkwater, representing District 121.
Thank you. Representative Gear.
Thank you, Madam Chair. Good morning, everyone. I'm Tracy Gear. I represent House District 9, which is Kennebunkport and Coastal Biddeford and Kennebunk.
Thank you. Representative Morris.
Good morning. I'm Representative Joshua Morris. I represent House District 75, which includes the communities of Turner, Leeds, and Livermore.
Representative Pebworth.
Good morning. I'm Sarah Pebworth. I represent House District 133 in the Blue Hill Peninsula.
Representative Prescott.
I'm Dwayne Prescott. I represent Waterboro and Lyman, House District 17.
Representative Rader.
Hi, I'm Amy Rader. I represent District 125, a portion of Bangor.
Thank you. And Representative Warren.
Good morning. I'm Representative Sophie Warren. Very fortunate to represent my part of my hometown here in Scarborough, Maine.
Thank you so much. That's our committee. We're also ably assisted this morning by our OPLA analyst, Steve Langland, as well as our committee clerk, Justin Purvis. We do have a bunch of work sessions in front of us, but before we jump into it, I've had a request for a quick 5-minute caucus. So Justin, if you could put us into our caucus rooms. For those tuning in, we'll be back in just about 5 minutes and jump right in. We'll also be taking the bills in numerical order for the work session. So we'll be starting with LD 548 and going from there. And with that, Justin, if you could use the Alice in Wonderland skills.
Mine is suggesting to go to breakout room. I don't want to get lost like I was lost on Monday. Don't lose me.
Senator Guerin, can you hear me?
I can now.
Okay, do you have the option to join room R?
We're going to breakout rooms already?
Is it Senator Guerin?
Yes.
Yes, we are. I'm sorry. I thought you had heard that. Yeah, so I sent you the option to join room R.
Okay. I didn't do that and now I'm not seeing it. Can you send it to me again, Justin?
I can certainly try. Hold on for me. Okay, Senator Guerin, is it asking you to join room D now?
No.
Okay. So there is something going on with getting you to join. So, because I can't put you in either room. So let me find out why that is. Sorry.
Okay. Justin, can you hear me?
I can, Senator Garin.
Some of the committees put up the LD number like in the corner of the screen or somewhere when we're discussing a specific, when they're discussing like LD 1879, they would have that up in the corner. That's helpful to be able to stay on track for exactly what bill we're on if you get up to get a drink or something. I don't know if it's something you could do.
Yeah, I can certainly do that. My current background will say is in caucus, but I'll change it when we start doing our work session to LD 548. If that's helpful. I don't know of another way to put it in the corner, but I can put it on my screen. Yeah.
Okay, thank you.
Yeah.
Hey, everyone, apologies. That was a legislative 5 minutes, which we know is code for time is a concept and flexible. We're just going to wait for a few more members from the caucuses to come back in, but we should be getting started soon. Or I'd say this is your 2-minute warning if you need to grab water or coffee.
Madam Chair,
Yes.
I'd like to note that the Republicans are here, ready to go and under budget.
And I would say getting a gold star for being ready and present. We're just waiting on literally 2 more members. I just pinged them and said that the clock is ticking.
Representative Drinkwater, if y'all are contractors, let me know. Because
I think
Yeah, I was also curious about that concept of a budget for this. So yeah.
well, I think we've got everyone back. Let me just do a quick head count, but I think we've got everyone. Okay. Thank you for everyone's patience. Sorry about the delay on that. We're going to jump right into our work sessions. Just a reminder, a work session is a chance for the committee, after taking public comment and testimony, to review everything in front of us and make decisions and have a discussion on the piece of legislation in front of us. And we may invite members up to answer different questions, members of the public as well as bill sponsors, but this is a process to continue the fact-finding part of our work here. And Representative Bradstreet?
Thank you, Madam Chair. I think this might be a good time for me to mention something that happened over the weekend. I was at a Chamber of Commerce meeting up at Sunday River. One of the topics of conversation was the inability of some of the public to witness some of our hearings, inability to get into the work sessions. They specifically cited 3 bills, and 2 of them had come before this committee. Mm-hmm. So the things that they're concerned about primarily were concept bills becoming effectuated too quickly, and amendments coming too quickly that the public is not able to look at them and offer their input. So I'd just like to mention that I may be opposed to some things coming up because I think maybe not the specifics within the amendment or bill, but the fact that we need to bend over backwards to be transparent so that people who are affected especially can have their say before the Maine legislature. I take some of that responsibility or blame upon myself because I mentioned that sometimes we get to hear, we kind of forget about what we're doing. We're so focused on what we have, and we understand a lot of things that sometimes we forget the public may not. So thank you. I thought this would be a good time to bring that up. Appreciate it.
Of course, absolutely appreciate it. And I'll kick it over to Representative Sylvester because I do see his hand is up. But I do want to say that, this has been a really difficult session, I think, for everyone as we navigate this. And I know I'm new on this committee, but I know all of us here are committed to exactly what you just said, Representative Bradstreet, and finding the best ways possible to make this technology work for us. And, I always come from the perspective of it's better to be slow and deliberative, even if it means tabling things for more information. So I just want to say, as the new chair, always please know if you need more information, if you need something, please raise your hand. The goal is to make sure we're working together. It doesn't matter what the letter is after our name. We're here to make Maine a better state. And so, it's upon all of us to work harder towards that goal that you're saying. And also, just as a reminder for anyone watching this on YouTube, if you ever have questions or you're ever trying to get testimony or trying to figure out schedule, we have our amazing clerk, Justin, reaching out to him. He's the one who, along with Steve Langlin, our analysts, are the ones who really keep us in line and keep us in check and make sure that the ship keeps moving ahead. With that, Representative Sylvester.
As you know, Representative, it was something we struggled with at the beginning of last session, trying to figure out how to make sure that concept drafts don't show up with amendments in the day. And so one of the things that Senator Hickman and I started, and it's mostly on my plate, is to reach out to folks who have concept drafts. And we've been doing so since the beginning of the session to make sure that those drafts come out with enough time for people to see them. And the other thing two things that we instituted was, one, to change the work sessions so that everyone who is on the interested party list gets an invitation. So if someone wishes to be in this work session, literally all they have to do is tell Justin they want to be on the interested party list, and they will receive more email than they ever wanted, including invitations to all of our work sessions, amendments as they come out, and any other kind of that sort of documents that we get from sponsors who are changing things. That all goes out through the interested party list. So that's all they have to do in order to be as informed and more informed than they ever wanted to be. So if people are having a problem with that, they should definitely reach out, and I'd be happy to do that. But we are making sure that the language of concept drafts come out hopefully a week before they get heard, so that everybody has a chance to parse them.
Thank you, Representative Sylvester. And, before we jump back in, I think this is a really important conversation about, norm setting and how we process everything as a committee, and just want to remind everyone, if there's anything we can do to help in this process, please let, myself and my co-chair know, we're trying to make sure that we get everything done in a timely process, but we also want to make sure that everyone has all the resources they need. So please never be, afraid to raise your hand or, send us a, email and go from there. And I just looking forward to it. I think we started some great work on Monday with some great conversations and had some strong reports come out of this committee. So let's, keep that moving forward and keep working together to see what we can get done. Any other questions before we jump into our work sessions? Okay, let's get this going. I think we're not going to go with the basketball metaphor from Monday, but maybe find a new one. But with that, open the work session on LD 548, an act regarding penalties from the early retirement for certain members of the Maine Public Employees Retirement System, which was introduced by the late Honorable Donna Dorr. And with that, recognizing and keeping her in our hearts, Representative Sylvester, question before I turn it over to Steve?
No, I just, I forgot we were going to Steve, just to be honest. So I will hold my question or my thoughts.
That's
I'm happy to at any time defer if the committee is ready for a vote. And then if I have any clarifying questions on what the committee decides, then I can ask at that point. So I know that typically what's happened in this committee is that I've gone through the analysis. But if the committee doesn't need that or doesn't feel that it wants to take the time to do that, then that's totally fine. And I respect that will of the committee, and I'm happy to accommodate that.
I would appreciate us going through the analysis, especially, being a new member of this committee. So let's jump in there. Thank you.
Yeah, just wanted to throw that out there. So beginning October 1st of last year, so this is a carryover bill, so the date would need to be changed if the committee decides to go forward with this proposal. The bill changes the rate of the penalty for those state employees who retired between July 1st of 2011 and January 1st of 2012, and for teachers who retired between July 1st of 2011 and July 1st of 2012, who had at least 25 years of service on July 1st of 2011, but had not attained 62 years of age, to 2.25% for each year the person was below 62 years of age upon retirement from service. So as I noted, the bill has an effective date or an application date of October 1st of last year, because obviously this bill was heard first in the first regular session. Current law imposes a 6% benefit reduction on employees who did not have 10 years of creditable service as of July 1st of 1993 for each year that their age is below age 62. Prior to that change, the reduction was 2.25% for each year below 60 years of age that the person retired. We did receive a preliminary fiscal impact on May 6th of last year, and the cost estimate at that point was about 5.9 million, but obviously if the committee decides to go forward with this proposal, it will go through the fiscal process again, and that number is subject to change. I'm happy to answer any questions.
Representative Sylvester, now the floor is yours.
Thank you. Thank you, Steve, for reviewing this with us. Folks who've been were on the committee on the 129th and 130th, Representative Bradstreet, Representative Morris, Senator Guerin, you will remember this bill. Then it has come every year. It is the bill for those folks who during that period, in that time of 11 to 12, were given the choice of taking their medical retirement or to take their full retirement. And, I think have our thoughts about whether or not that is a good thing or a bad thing, or, whether it should have happened, whether people made choices. I think that we've all sort of, thought through, where we stand on that. The 6 million that's in there is going forward. So prospectively, if we went retrospectively, it's hundreds of millions of dollars. But I say all of that as a review for folks, but this is sort of where this bill is right now. I had conversations with lots of different folks, including the governor's office, in terms of ongoing negotiations about cost of living increases and how to handle them going forward. If they may not reach any sort of compromise or agreement on that, they might. But if they do, this would be the vehicle that would be used to do that in honor of Representative Dorr. And so that's, why I think it's very important that this bill get moved forward. I think, no one on this committee who served with Representative Dorr doubts that her last wish is to do something in favor of state workers. And so I just wanted to make sure everybody knew that, where this bill stands. It's going to go to the appropriations table, similar to, if it passes, similar to it did in the 129th. And that'll be appropriations to try to figure out whether there's $6 million. But more likely, this bill will be used as a vehicle for coming to some sort of an agreement in her honor.
Thank you, Representative Sylvester. If I can ask a clarifying question, are you saying to move it forward or to keep it tabled in committee as a vehicle for something else?
I am about to make a motion to move it forward. I think folks voted, feel that this is something they support or don't support, and I think they should vote on the bill. I just wanted you to know that because, folks knew Representative Dorr and care about her, that was something that's out there.
Absolutely. Thank you for that clarification. Do I have any other questions or comments from the committee? Seeing none, I think we're ready for that motion that you mentioned, Representative Sylvester.
I would move ought to pass as amended with the fiscal note.
Thank you. We have a motion on the floor. Do I have a second? Seconded by Representative Cuddy. And before we move the motion, Steve, you have a question?
Yeah, so as I mentioned, the bill says beginning October 1st of 2021. The motion didn't indicate whether that date was going to be August 1st of 2022 or October 1st of 2022. So I just wanted to bring that to your attention.
What would you suggest, Steve? What would be most regular?
I think because this bill was worked in the first regular, and that session is longer, it was October 1st of last year because it would be 90 days after adjournment. And I think maybe August 1st of 2022 would be probably in line with other bills in this situation.
Then then I would abridge or amend it to my amendment, my motion to include the correct date, August 1st.
And is that, I'm seeing a thumbs up from the second from Representative Cuddy. So we have an amended motion in front of us. Any discussion on the motion? Seeing none, Justin, would you mind calling the roll, please?
Senator Daughtry,
Yay.
Senator Daughtry, yay. Senator Guerin,
No.
Senator Guerin, no. Senator Hickman,
Yay.
Senator Hickman, yay. Representative Sylvester,
Yay.
Representative Sylvester, yay. Representative Bradstreet,
No.
Representative Bradstreet, no. Representative Cuddy,
Yay.
Representative Cuddy, yay. Representative Drinkwater,
Nay.
Representative Drinkwater, nay. Representative Gear,
Yes.
Representative Gear, yes. Representative Morris,
No.
Representative Morris, no. Representative Pebworth,
Yes.
Representative Pebworth, yes. Representative Prescott,
No.
Representative Prescott, no. Representative Rader,
Yes.
Representative Rader, yes. Representative Warren,
Yes.
Representative Warren, yes. The motion is 8 in favor, 5 not.
Thank you, Justin. And do I have a minority report?
Ought not to pass.
Ought not to pass. Thank you so much. The motion carries of ought to pass as amended. Before I close the work session, I just wanted to have a brief moment of silence in Representative Dorr's memory. And with that, I will be closing the work session on LD 548. Moving on to the next bill in front of us, I will open the work session on LD 1240, resolved to review barriers to regional solutions for housing choices. And I'll kick it over to Steve.
Sure. So this is another carryover bill. This resolve directs the Department of Economic and Community Development, DECD, the Office of Community Development to conduct a review of barriers to regional solutions to making housing affordable, accessible, available, functional, and compatible with strategies outlined in the December 2020 Climate Action Plan of the Maine Climate Council, titled Maine Won't Wait, a 4-year plan for climate action. It also directs the office to report to this committee by December 1st of 2021 with a summary of these barriers, their implications, and potential solutions. If you recall at the work session last year, the department testified they don't have expertise within the Office of Community Development on climate change, transportation, or land use. They said that they would need to hire a consultant, and they thought that the minimum cost would be $300,000. There was discussion at the time of potentially using ARPA funds, but at that time, the Department of Treasury hadn't issued guidance on whether those funds could be used for that purpose. And so they had asked this committee to carry it over, which this committee voted to. So there was the anticipated one-time general fund appropriation of $300,000 for the consultant. And that was sort of where the bill stood when it was carried over last session.
Thank you so much, Steve. I know we have the bill sponsor with us, Senator Vitelli. I don't know if she is available or like to add anything about the current status of the bill. See if she's able to join us. Okay, looks like she's not able to pop in at this time. So do we have any questions from the committee?
Yeah.
Representative Sylvester, followed by Representative Cuddy.
There we go. I just wanted to pass along the communication if that would be proper at this moment, Madam Chair.
Go right ahead.
So Senator Vitale reached out to us and wished that we might table this bill so that after all the other housing bills get passed, there's something that the committee feels like it needs to do. We have a vehicle for it, and or barring that, we had talked about as a committee having a session where we talked about housing issues and saw whether or not we could come to some sort of bipartisan piece of legislation that would fix something that we could agree on, which might or might not happen, but would be certainly be an interesting afternoon. And so that's, but she's asking us to table it for today.
Thank you, Representative Cuddy.
Actually, what I was going to say was that without Senator Patelli here, I was sort of hoping we'd wait and table it. So instead, I think, having heard that, just make a motion to table the bill.
If I can ask real quickly before anyone seconds that, I just wanted to see if she was able to join us because she is in the Zoom. So I'm going to try one last time to give her that opportunity. And if she is able to rejoin us after the tabling motion, we can always bring it back up or invite her to see if there's been any updates on her bill. But seeing that it doesn't seem like we're able to get a hold of her, if you wouldn't mind making that tabling motion again, Representative Cuddy.
I would move to table.
Do I have a second?
Second.
Seconded by Representative Gear. And for this, I think we're just going to do a show of hands. All those in favor of tabling this bill until later in the session, please raise your hand and keep it up. Thank you, Representative Warren. It is almost unanimous of those present and voting, with the exception of Representative Drinkwater. So with that, tabling the bill. Senator Guerin.
It's up in error. Sorry.
Oh, no worries. No worries at all. Okay, so we're going to move on to our next bill. We're going to open the work session on LD 1881. An act to clarify the laws related to the use of medical marijuana and workers' compensation, from Representative Dillingham, and kick it over to Steve.
Sure. So this bill provides that a decision, lump sum settlement, or agreement under the Workers' Compensation Act may not prohibit an employee from engaging in conduct as a qualifying patient pursuant to the Maine Medical Use of Marijuana Act. The Maine Medical Use of Marijuana Act may not be construed to require an insurance company providing workers' compensation insurance to reimburse a qualifying patient for those costs associated with the medical use of marijuana. And the Workers' Compensation Board must exclude evidence of an employee engaging in conduct as a qualifying patient authorized by the Maine Medical Use of Marijuana Act in any proceedings before the Workers' Comp Board. I included a little bit of sort of how the process of workers' comp works. So initially, there's a troubleshooting phase, which is sort of an informal way that to hopefully resolve the issue. So a troubleshooter will call the parties involved and attempt to resolve it. And if that's unsuccessful, then it goes to mediation. And if there is a resolution in the mediation phase, there's a written binding agreement that's signed. If mediation is unsuccessful, there's a formal hearing, and if petitions are filed, there can also be a formal hearing. So at that point, an administrative law judge will issue a written decision. And if the party disagrees with the ALJ decision, it can appeal to the board's appellate division. And that's usually where 3 ALJs review written arguments, and they sometimes hear oral arguments, and then they issue a written decision. And finally, if the party is not content with the decision from the appellate division, it can always appeal to the law court, but the law court has sole discretion as to whether it decides to take on that case. I did include a couple of excerpts from the Maine Medical Use of Marijuana Act that I thought the committee might find helpful. There was discussion particularly surrounding paragraph B, an employer. This chapter cannot be construed to require an employer to accommodate the ingestion of marijuana in any workplace or any employee working while under the influence of marijuana. The medical marijuana law also says that an employer cannot refuse to employ or penalize a person solely for their status as a qualifying patient, unless failing to do so would put the employer in violation of federal law or cause it to lose a federal contract or funding. There was discussion at the public hearing about prescribing. The term is actually written certification. I think that was noted. So medical provider, which is defined as a physician, a certified nurse practitioner, or a physician assistant, provides written certification for the use of medical marijuana. It's not technically prescribed like it would be for other drugs. I also included the definition of qualifying patient. There was discussion that there was a law court case, Burgoyne v. Twin Rivers Paper Company, which did hold that a workers' compensation insurer cannot be required to reimburse the employee for the use of medical marijuana. And that is explicitly stated in Section 3 of the bill as printed. There was also discussion at the public hearing about occupations that require drug testing or that have a zero tolerance policy for marijuana use. So some professions, such as commercial motor vehicle operators, require a commercial driver license or CDL. So it would be a bus driver, a plow driver, or any vehicle designed to carry 16 or more passengers, including the driver. Federal regulations stipulate that no driver shall be on duty and possess, be under the influence of, or use any of the following drugs or other substances. And it specifically lists Schedule I substances, of which marijuana is a part. I should also note a person could be disqualified if they drive a commercial motor vehicle under the influence of a Schedule I drug, or if that person transfers, possesses, or unlawfully uses a Schedule I drug. I included some information about the frequency of testing. I also included some information in my analysis about the state of Maine testing. So there is a statute that governs Maine substance testing, but it specifies if an employer wants to establish a drug testing policy, it has to be in accordance with the statute and with rules that are adopted by the department. And the Department of Labor actually has to approve that policy before it's implemented. Last year, the committee received a report from the department, which said that there are 536 policies that were approved and active. I would note also that the state's policy on drug testing does not apply to any employer that's subject to federally mandated substance use testing program. So if an employer has any employees who are subject to that federal mandated drug and alcohol testing program, that employer can expand the federal testing pool to cover all employees and forgo a separate policy with the state. Some of the concerns that we heard from the public hearing, and I know that there are certainly others in the room that are probably better able to speak to these specific issues, that the bill would take the expertise of the administrative law judges out of their hands by requiring them to exclude evidence of medical marijuana use. An agreement between an employee and an employer could be difficult because agreement could specify drug testing as part of return to work agreement. And if enacted, this could put that in question. And there could be, the agreement could be an offer of a light duty job to return to work, such as a commercial vehicle operator or another position that requires drug testing per company policy or other regulations. And that could be non-workable for the employee and the employer. We don't yet have any fiscal information on this bill. As I noted, I know that John Rohde, the Executive Director of the Workers' Compensation Board, is here, as well as I think I saw Elizabeth Brogan too. So if the committee has specific questions, I think I'm happy to try to answer them, but there's some experts in the room. So.
Thank you so much, Steve. Do you have any questions from the committee at this time? I know that was a lot of information to digest, but we have folks present who can answer any questions you may have. Representative Sylvester.
Thank you. I'm sorry, my buttons are very slow today. If we could have Director Rohde come forward, that would be great. But I would cede to other folks who have their hand up before.
Let me see what Representative Pebworth has to say, and then we'll invite John Rohde. Give him a split second if you can hear his name. His ears burning that we're going to have him on deck. Representative Pebworth.
Thank you, Madam Chair. I was actually just working to pull up Mr. Langland's analysis. In particular, of concern to me is I think they're ALs in shorthand, being unable to consider medical marijuana use. So I'd like to hear a little bit more about that. If there's somebody here who could speak to that, or Steve, if you could elaborate a bit more. Is there any other substance or anything else that we've limited in that way, the way that this bill would do?
It appears the way it's drafted that this is the only sort of exclusion. There might be something else to that I'm not familiar with, but in looking at the statute in the bill, it's sort of unique in that, in at least where it's drafted, that it says that this specifically must be excluded. But I would defer to Executive Director Rohde.
I would say, Director Rohde, if you wouldn't mind jumping in, if you have information on that. I know we have other questions for you as well.
Sure. So I think Steve's correct that this would be a unique provision to exclude an entire class of evidence. I think there's a provision that was a holdover from years ago about undue influence in certain testimony, but for the most part, the line you see there about the judges have the discretion to admit evidence if it's something people would rely upon is the standard that applies in all comp cases here at the board. So this would be a different standard for this one class of evidence.
Okay. Representative Sylvester.
Thank you. I guess I have two questions, Director. The first one is the intent seems to be that the sponsor is worried about the time between when somebody is injured and the time in which they've returned to work. And I've tried to do some homework, but asking folks who've been involved in the workers' comp system for a long time, since medical marijuana has been on the books for a while now, nobody could remember a case where an attorney for the insurance companies tried to use the fact that somebody was using medical marijuana to just outright deny the claim. And so I guess I'm asking, is the use of regular prescription drugs ever used that way? Understanding that on return to work, that capacity is a vital issue in terms of the ability to return to work. But in the time between injury and return to work, can you ever remember either prescription or medical marijuana being used to preclude someone from getting a workers' comp claim?
I can't. I did a search of our decisions for the phrase medical marijuana and came up with very few. As Steve mentioned, the Burgoyne case was, I think, 2018. So we don't see much mention of it in board decisions, but I'm unaware of any situation where the mere fact that somebody used medical marijuana resulted in their claim being prejudiced, if that's the right phrase for it.
Quick follow-up, Madam Chair.
Absolutely.
Right now, do you feel like the board treats medical marijuana in the same way that it would other prescription drugs, or do you think that we need to clarify that it should be treated the same way?
Yeah, I think our judges do a good job of exercising the discretion that they have, right, by statute and in terms of their job, in terms of weighing what's going on. The only difference, of course, well, could be a couple of differences, I guess. With medical marijuana, it's not reimbursable pursuant to the Burgoyne case, first of all. So there'll be that distinction, of course. And there may be, I don't know this for sure, but I think there may be a difference of opinion amongst medical practitioners as to whether medical marijuana is or is not an appropriate therapeutic in a particular case. That may come up. I don't know for sure, though.
Thank you.
You're welcome.
Representative Prescott?
Thank you. Would there be any conflict with federal law if we ran it through the same program and it would be considered while making decisions?
So if I can, I'll steer away from weighing in on what federal law implications might be. I would know what the impacts would be within the Workers' Compensation Board. If the language is limited to proceedings here at the board, it shouldn't have an impact elsewhere. But some of the testimony was a concern that the breadth of the language might lead to a situation where there could be a conflict with either medical marijuana law or state law, maybe even federal law on marijuana in the workplace. So, but that's not my area of expertise necessarily. So I would probably be the wrong person to ask about that.
All right, thank you.
Do I have other questions of the committee? Representative Cuddy.
Thank you. I'm sorry, I could not make my Zoom hand go up for a second there.
No worries.
Question for Mr. Langland. I'm going back through in the case of Burgoyne v. Twin Rivers. That's the case that held that a workers' comp insurer can't be required to reimburse the employee for the use of medical marijuana. I am reading the bill. I'm just looking at the summary right now. Summary point 2 is that the Maine Medical Use of Marijuana Act may not be construed to require an insurance company providing workers' compensation insurance to reimburse a qualifying patient for costs associated with the use of medical marijuana. So it seems that the bill's intent there, as I read it in the summary, is aligned with Burgoyne. Is that correct?
The way that I read it is that that provision of the bill sort of codifies what the law court found, and that explicitly says that a workers' comp insurer cannot be required to reimburse for medical marijuana.
Okay, that was my assumption, but because when I looked at section 3, it references Title 22, section 240, yada yada yada, and I have not had a chance to go back and look at that to ensure that it's in a place where it actually does that. But that's okay. Thank you. I just wanted to make sure that those two things were actually in line. It was essentially doing that piece. Thank you.
I have Representative Bradstreet, followed by Representative Gear.
Yes, I just wanted to state, Madam Chair, that I've texted the sponsor, but I haven't had a response yet.
I should add, I did hear from Representative Dillingham. She's having a health emergency this morning. Everything's fine, but she might not be able to join us. She did let us know. And she sent us some thoughts on the bill of just really hoping to find a way to make this work. But definitely, if we're able to have her join us, we'll be able to bring her in. But just to let folks know that she may be unable to join us this morning. Representative Gear.
Thank you, Madam Chair. This might be a question for Director Rohde or anyone else who would be able to weigh in on this. One of the things that I think this bill is really trying to address is any potential chilling effect of how medical marijuana is being treated in workers' comp cases on employees using medical marijuana as a viable alternative to opioids for pain management, given the crisis that we're in regarding opioids right now. So I would just be curious in terms of Director, or your knowledge or anyone else's knowledge, has there been any research, or are there any, is there anything that we can look to for looking at that aspect of this, which is, I think, a very, very real concern?
Director Rohde.
Okay, so I had a glitch, maybe it was on my end, so I may have missed the entirety of your question, but it sounded like, is there anything here at the board that we could look at to see if, maybe stigma is the wrong word, but if there's any sort of stigma attached to the use of medical marijuana and therefore it leads to a different result than might be the case if a person was using a prescribed opioid? Would that be?
Yeah, I mean, I think we're really just looking at the question of, is there evidence that there is a chilling effect that might be being contributed to by the way medical marijuana is being treated in workers' comp cases that could deter the use of medical marijuana as an alternative to opioids for pain management in these situations? I think that's it's a very real concern given the crisis that we're in at the moment.
So I don't know of any off the top of my head. Just thinking out loud, we have worker advocates here who represent injured workers at the stages of mediation and beyond. There are also obviously lawyers who represent injured workers. The best way for me to get at that would probably be to survey the folks who are representing injured workers to see if they're seeing any impact of that. But as far as a broader statewide or national study, I'm unaware of any at the moment.
Thank you.
You're welcome.
Representative Warren?
I don't know if there's anyone here at this work session who could speak to Representative Geer's question.
Representative Warren, it's hard to hear you, but I think you said if you're wondering if anyone would be able to answer Representative Geer's question. Is that what you're saying? If there is anyone who has anything else to contribute in addition to what Director Brody said, if you could please raise your hand in the work session. I am not seeing anyone. This could be something that we can ask our analysts to look into a little bit further and get back to us if it's a matter of clarity for moving forward. Representative Prescott?
Thank you. This is for the committee. Is anybody interested in removing that clause that denies it as being considered evidence?
I am seeing faces and nods going in 3 different directions. So I don't know how helpful that is for you, Representative Prescott. I don't know if people have different ways of nodding or shaking their head, but I'm seeing a few circles happening. I don't know if anyone would like to jump in and respond to Representative Prescott. I, for myself, am still trying to figure this all out.
All right, I guess not.
I mean, I would say I'm sorry, Senator Daughtry.
No, go right ahead.
I'm not opposed to that, Representative. It seems to be out of step with what is currently taking place at the board and in the with the law, with the justices there, when they're hearing these, it would be unique in that way. And similarly, we seem to be treating medical marijuana differently than other medications. It seems as though, like, if somebody can be prescribed a painkiller or whatnot and be able to return to work, and somebody's doctor believes that medical marijuana will help them, it seems like treating those two things as differently doesn't make a great deal of sense. So I think this has been a difficult one for me to understand exactly and figure out where I'm landing on it. But I sort of feel like removing it from evidence treats it uniquely. And I'm not sure, and I don't think I want to do that. But also denying, the ability to deny someone's claim based on using it, if you couldn't deny the claim for other if they were using some other prescribed drug, then we're treating uniquely again. So I think in both those places, I'm sort of, just to give you a sense of sort of where I'm leaning right now, I guess.
Follow up from Representative Prescott, or should I kick it over to Representative Sylvester?
Thank you. Can I get some examples of why these claims would be denied? Because I'm thinking, the only thing that pops in my head is maybe somebody is using painkillers excessively. What kind of reasons are things denied for the use of any kind of drugs?
I think this would be a question for Director Rhodey.
Please.
Jumping in, Director?
Sure. So I think the way you might see a case, the denial in a situation like this would more than likely either be because the prescribed treatment wasn't related to the work injury, would be one of the basics, or what the statute says is, and I might get this a little bit wrong, but essentially the treatment has to be reasonable and necessary. And so you may get an argument that what was prescribed was either unreasonable or is unnecessary. Maybe you've progressed to the point in the injury where a doctor might say you no longer need a particular form of treatment, and you could have a debate obviously about that, and the case could revolve around those issues. Those are the likeliest places you would see it. I don't know that I've ever heard of a case where for any prescription medication, somebody said, well, your claim shouldn't be compensable at all because you are using a particular drug, right? It could be a factor in the middle causing, maybe the time lost from work is no longer attributable to the injury, but other issues, but not the case itself being non-compensable, if you will, if that helps.
Yes, it did. Thank you.
You're welcome.
I have Representative Sylvester followed by Representative Bradstreet.
Thank you, Madam Chair. Since we've been doing such a great job of coming to consensus, normally I might just throw this out there, but I'm going to throw out something I just scribbled down to see what people think about it in terms of trying to get at what Representative Dillingham is trying to get at. So I'll read it twice because you don't have it in front of you, and then I'm going to try to put it into the chat. All right. The use of medical marijuana, and this would be, I think, a replacement of the bill, but Steve can guide us on that. But the use of medical marijuana post-injury shall be treated similarly in evidence as the post-injury use of prescription pain medications, and shall not be the sole reason for denying a compensatory claim of injury. So that makes clear that it should just be treated as other pain medications, and that it shouldn't be the sole reason somebody gets denied. And I think that is what Representative Dillingham is trying to get at. Okay. Thoughts, questions, feelings, concerns, funny quips.
Thumbs up. Getting some laughter from Representative Prescott. I know Representative Sylvester just threw that out, but I do have Representative Bradstreet and then Representative Prescott. I'll kick it over to you.
And that's pretty much right on target where I was going. It sounds similar.
Madam Chair, I will defray my comments now until we have a chance to talk about what Representative Sylvester just offered. So I'll hold.
Thank you, Representative Bradstreet. Representative Prescott, so you think that's sort of moving in a similar direction where you were going?
Yes.
Okay. Representative Bradstreet, kick it back to you.
Thank you. Just a comment. I know we're talking about prescribing, but I know in the analysis it talks about the medical marijuana being dispensed rather than prescribed. So there's a slight difference there. I'm also wondering if, unlike other possible prescribed medications, I think the issue is, does the medical marijuana have ongoing effects that would have a negative impact on the people's ability to perform and open up the employer's possible liability should they feel pressured to let someone. I think, I agree with the efforts of this bill to bring medical marijuana into the picture. I think it needs more work and more maybe some clarifications before I could vote for it.
Duly noted. Representative Bradstreet, any responses to that? Or wow, we had a lot of hands go up in a short period of time. Representative Rader, were you wanting to respond to what Representative Bradstreet said?
Yes, just because I want to use my University of Maine education. I took a class called Law and Policy of Cannabis, and we were studying kind of in depth medical marijuana, how it's prescribed and the laws around it. So you're correct in that it's dispensed instead of prescribed. So when you get your medical card, then you go to a dispensary or a caregiver. In the state, we have 4 state licensed dispensaries. All of the little mom and pop shops you see are technically under a caregiver license, which is slightly different. They all function in the same way, though, that if you have your medical card, you go in, you speak to somebody at the dispensary, and based on what the doctor told you when you got your medical card, they work in conjunction with you to see what is going to alleviate your symptoms. So you're correct in that it's not as highly regulated as prescription medication, but there are touch points on either end to assist the patient with finding the proper medication for them. Thank you for that one class on law and policy of cannabis, University of Maine.
I feel like you needed some PowerPoint slides to go with that one as well, Representative Rader. So I have Representative Gear, Representative Morris, Representative Cuddy, Representative Rader again, Senator Guerin, and doing full circle back to Representative Sylvester. So with that, Representative Gear, the floor is yours.
Thank you, Madam Chair. I just wanted to weigh in and say that I support Representative Sylvester's approach to this. I do think it really focuses in on the intent of Representative Dillingham's bill, which really is to acknowledge that medical marijuana can be viewed or treated differently. And this really just aligns that that piece of it with practice. And so I do support that approach. I still am noodling a bit, but thanks.
Thank you, Representative Gear. Representative Morris.
Yes, thank you, Madam Chair. I'm reading Representative Sylvester's amendment, and as I understand it, my only, I wonder, I think he is trying to get at the heart, at least in the conversations I've had with the sponsor on what we're trying to do, and I think we all can agree that bringing medical marijuana, that nobody should be denied on that basis. The only concern I would say is there a way to put something in there that obviously some of the concern brought forward by the employer community deals with federal law as it relates to this, because marijuana under federal law is still illegal. And I don't know, I'm not sure if anything needs to be put in there, but I just think it's something else to consider. Because I think that's where a lot of the concern in the employer community comes, is we don't want to be in a situation where we're putting them in conflict with federal law through a state law. I think that can be problematic. So I don't know if there's a way, if that language would need that amendment, or if there's a way to put that in some sort of an amendment. But obviously that's where my biggest concern is. And I am not a lawyer, so I don't know.
No worries, and duly understood and agreed, Representative Morris. Is there anyone here who could sort of help us noodle along with what Representative Morris was saying? With that, if anyone thinks of anything, let us know. I'm going to move on to Representative Cuddy, followed by Representative Rader.
Thank you, Senator. I think this is probably a question for Director Rohde. The one thing that sort of in reading through the bill and listening to testimony that I think I do sort of like in theory is Section 4 of the bill that talks about a decision or lump sum settlement or agreement can't prohibit an employee from seeking a determination of rights under the Act. And is there anything, like how, I guess, sort of how frequently, Director Rohde, would that even happen? And I don't necessarily mean with medical marijuana, but with anything. Are there often decisions, lump sum, well, not often, are there decisions, lump sum settlements or agreements under the Act that end up prohibiting an employee from engaging in a particular conduct?
So I don't know of any, right? So, not to split a hair, but obviously if the decision is a particular treatment isn't going to be compensable, that may lead to somebody not using it. If it's going to be in an agreement, and again, I don't know of any, I asked around and I didn't hear of any situations where agreements like that, that at least the judges knew about, but if it's an agreement, then both parties have agreed that this is what they want to do anyway, and either the mediator or the judge would be just approving something that the parties have consented to. But I don't know of, in terms of treatments, that it's really generally done that someone could be prohibited from engaging in a particular form of treatment.
Okay, thank you. I apologize because I did miss a portion of this hearing, so I apologize if that question was asked and answered before, or but that would not apply to a decision on that. That would be an agreement wherein the two parties have agreed to what they're going to do. But then if there is a decision, then that actually comes from the law judge, correct?
Right. And I think mostly what you wouldn't see somebody say you can or can't do something. I think what you might see is it is or is not compensable, and therefore the insurer or self-insurer wouldn't have to pay for it. And then it's obviously up to the employee as to what to do at that point, whether they want to pay for it themselves or not.
Okay. Thank you very much, Director Rhodey.
You're welcome.
Up next, Representative Rader, did you still have a question?
No, I had just raised my hand to answer Representative Bradstreet's question. Thank you, though, Madam Chair.
Of course. Senator Guerin?
I was wondering if we could hear from Elizabeth Brogan.
Absolutely. I do believe we have Ms. Brogan with us, so I'll invite her to step forward.
And one thing I would like to ask her, or maybe I should wait till she's through the tunnel.
She's with us. I just asked her to see if she can unmute, and there she is. Okay.
Yeah. So do you think there is a need for this? Are you denying claims because of marijuana?
I have not heard of any claim ever being denied for marijuana. I have asked around. I'm in touch with a lot of insurers. Now, I'm not talking to advocates and employee attorneys about this. I would defer to Director Rhodey on that. But I have not heard of any claims being denied or any kind of prejudice. I mean, it was really kind of a surprising bill to me, because I don't see that prejudice, to be quite honest. So I don't think it's necessary. I think part of it has already been handled by the law court, although it would codify the fact that employers don't have to pay. But I don't see the need to reiterate in the Workers' Compensation Act that employees may not be denied any right or privilege, because that's already, as Mr. Langland pointed out in his excellent analysis, part of the Medical Marijuana Act.
Thank you.
Sure. Do I have any other questions for Ms. Brogan while she's with us? Representative Sylvester.
Thank you. Senator Guerin, you stole my thunder. I was going to call Ms. Brogan forward, and that would have meant within a 1 week period that I had not only admitted that Mr. Gore was correct in something, but that I had called Ms. Brogan forward. But that's okay. That's all right.
2022.
So, Ms. Brogan, and I'm looking at this bill the same way. It seems to me to be a crazy legal strategy, because we're looking at two different parts of the law, right? I guess I'll start with that. We're looking at the deciding whether or not something is a compensatory injury. That's one piece of the decision. And then on the return to work is a whole separate set of rules and laws about return to work, right? And so and I know you are, you're all very good at your jobs. You parse through the record. You're representing your clients to their fullest, trying to find reasons that perhaps this claim is not compensatory. If it was a good strategy to say somebody was injured and they took pain medication, I guess that would be the big baby rule, right? Like you're not supposed to be able to use medication to, post-injury. I mean, that's really what we're talking about here, is that somehow there would be a claim that would be denied because somebody used medical marijuana post-injury. So that doesn't seem to me to be an argument that makes any sense.
I've never heard of a case where that happened. I'm not familiar with the big baby rule. I'm sorry.
I don't think so either, right? I was injured at work. I took pain medication so I could do my physical therapy, and nobody said, oh, you got to tough it out.
People are taking all kinds of medications all the time.
Absolutely. All right. So really what we're talking about here is making sure that in some future period, medical marijuana isn't viewed in such a way that it is, that it is viewed in a different way than perhaps we're viewing it right now, right? And so it's some sort of a prescriptive codification of our views on medical marijuana as an appropriate pain medication. And then just to safeguard what the speaker or what the sponsor is looking for, to say that it can't be the sole reason. I can't see why it would ever be the sole reason for denying a claim that someone took pain medication after they were injured. But we go ahead and say that so that if anybody ever wants to, does that seem reasonable to you? I mean, it doesn't in any way change anything that I can see, but it does sort of say what our views are on.
Yeah, I mean, your amendment is certain, your proposed amendment, certainly a vast improvement because it gets to the heart of what the concern of the sponsor is, right? I don't see that it's necessary. And having just looked at it, I still don't know that I would say it's not. I mean, I do kind of have a concern about, there are some employers that have to be very careful about federal law as well. I don't know if this language would be problematic, having just looked at it.
Sure, I appreciate that. Thank you.
Any other questions for Ms. Brogan? Representative Warren?
Thank you for being here, Ms. Brogan. I'm wondering what you would think about a perspective that I'm processing. I believe in an answer to an earlier question, you said both that you hadn't spoken much to or hadn't consulted with those who may have gone through this process, and also and neither the lawyers representing different employees, but you're also saying that you don't think this is necessary. Just to clarify, I guess you're saying that from the position of certain employers, but it doesn't seem like maybe you're the person to consult with if we're interested to know directly impacted communities, perhaps.
I would completely defer to Director Rohde on any study of what's actually happened in all those cases. I don't have access to that. If there's been a case that has mentioned medical marijuana, I'm not aware of it. I would just say that all of these cases have two sides. So if that happened, both sides would hear about it in that case. It's not really a one-sided thing where only one party would know if medical marijuana was relevant. I'm not hearing of its relevance at all, but Director Rohde would definitely have access to that, to the full amount of information.
Great, thank you very much. I have a broader follow-up question that, or I guess a point that goes to the amendment as Representative Sylvester has offered it. I guess I am curious if we all see there being a possibility of a larger compromise. For me personally, I have some objections to the amendment because I think that, equality or equity under the law, like versus equality, that we may want it to be treated in a non-discriminatory manner, but unless we take certain more, progressive steps to ensure that structurally, to right maybe a long imbalance, I'm not sure this non-discriminatory language will have the effect that we hope or intend. However, it would be wonderful if we could find a larger compromise across the aisle. So I am curious where different colleagues may be at this point.
Let that one sit and everyone can respond and think and consider. Thank you, Representative Warren. And Representative Cuddy.
Thank you, Senator. I really like the direction it's going. I like Representative Sylvester's proposed amendment. I think some of the things that I liked about the bill, I agree, seem like they're not necessary. And I don't, even though it can be good to get ahead of a problem, sometimes when you get ahead of a problem, you cause things to happen that you did not intend. I'm trying very hard not to use the phrase unintended consequences, but I did it. So I am, I don't see how what we have done, what Representative Sylvester has proposed for language would have an issue with the federal side, because in my mind, it's going to be what the administrative law judge says in his or her decision, or what the parties agree to, that's going to say what the employer has to do. And that's where a requirement that an individual be allowed to do something would come from, not from this, but I'm also aware that, last minute language changes, people need some time to see them. So I would, and I hate saying this, but I would be open to tabling the bill to give people time to look at it and think it through. And then come back to it at another time if that's amenable to people. Also understanding that I've just spoken, I know I can't make that motion.
I would say that I think you hit the nail on the head that for me, I need some time to digest this, especially with the bill sponsor being unable to be with us this morning. I would definitely be amenable to that, but knowing that's a non-debatable motion, would like to see if anyone else has any requests for information or anything else we can noodle out. Representative Sylvester and then Representative Pepworth. You're on mute.
Simply a point of information that I added a second piece that people might want to look at in the chat, and if Steve could capture that before it disappears into the void, that would be great.
Perfect. Representative Pepworth.
Thank you, Senator. I'm wondering if we do go ahead and table this, that might give people who have been denied an opportunity to step forward and share that information with us. Without that, I feel like the conversations we've had have put those who have these cases come before them a bit on notice, and that may be sufficient action for this committee to take at this time.
Any other comments, thoughts? Representative Prescott, did I see your hand going up?
After listening, it seems to me the only thing this bill really does is it wanted to deny marijuana to be used as evidence in a case. Because we've heard that it's already in place in the medical marijuana law to begin with. And I'm looking at these two amendments. So I'm okay with tabling it. But realistically, after everything I heard, that's the only thing I see this bill doing, was denying it to be used as evidence. So if we take that part out, add these two parts, I can see this bill moving forward.
Sounds good. Representative Gear, did you have your hand up? Okay. Anyone else? Going once, going twice. Representative Drinkwater.
Well, I've been pretty quiet on this so far, but I like the way that Representative Sylvester phrased it. I think this bill needs a little bit more polishing, so it'd be ready for prime time. So I'd like to make the motion to table.
Do I have a second? Seconded by Representative Gear. And with that, all those in favor, please raise your hand and keep them raised. Senator Guerin. Okay, so it is almost unanimous with the exception of Senator Guerin. And with that, I will close the work session on LD 1881. Thank you all for a very robust conversation. And our analyst, Steve, thank you for everything. And that is our coonhound, Bailey. I knew it was only a matter of time before the Labor Committee got to meet her. She likes to sing the song of her people every day. But with that, we'll make sure we check in with the bill sponsor and go from there. So thank you, everybody. And up next, we will open the work session on LD 1891, an act to continue supporting safe drinking water for Maine families, from Representative Fay. And I will kick it over to Steve for our analysis.
Sure. So this bill provides one-time funding for the treatment of contaminated private drinking water wells. I did include a link to the authorizing legislation from, I think it was 2017. So initially, the bill that authorized this program allowed up to $50,000 of the fund, a fund of $500,000, so $50,000 of $500,000 to be used for targeted outreach and marketing. And it allowed 15% of that $500,000 for program administration. Maine Housing did follow up and they said that previously they've only used 10%. So they're actually a little bit under the 15%. There was discussion about PFAS in the public hearing, and I did want to note that I did a little bit of research, and So the bill does mention maximum contaminant levels for public water systems as established by the National Primary Drinking Water Regulations. And I would note that the Federal Environmental Protection Agency announced in November of last year that it was asking its internal science advisory board to review draft scientific documents with the intention of forming a maximum contaminant level goal in a national primary drinking water regulation for PFOA and PFAS. So the proposed rule is expected to be announced in the fall of this year, with the final rule anticipated to be adopted in the fall of next year. The committee had several requests of Maine Housing, sort of put Mr. Jorgensen in the hot seat at the public hearing, and he followed up very expeditiously. And I've attached that to my analysis as well as forwarded that to you guys. So we don't have a preliminary fiscal impact statement at this time, but obviously the bill itself provides one-time funding from the general fund of $500,000 for the fiscal year 2023. And I'm happy to try to answer any questions.
Thank you, Steve. I have a question from Senator Garand.
Did you say Garen?
Yeah.
Or Garen? You said representative, so I thought it was Garen.
Oh man, I'm sorry. We've been on committees for too long.
Yeah. My question is not for Mr. Langland. It's an idea I have, so I can wait until.
I would say jump right in while I try to get the dogs down a level.
Okay, so here's a shocker for the committee, coming from me, I'm sure, being a fiscal conservative, but I have the idea that maybe we could double the amount of this money to $1 million. Ask Maine State Housing if they could do it for 5% admin costs. I think in this time when we have a budget surplus, it's an opportunity to fill that fund, and we know that the PFAS situation is exploding in Maine. So I think this is a chance to put some money in there where we have some extra money. I hope we give most of the money back to the taxpayers, but I think this would be a good use of an extra 500,000. So that would be my amendment proposal.
Thank you very much, Senator. And I would say just off the bat that I am initially amenable to that, and the dogs seem to have quieted. So I think you might have been the solution. They might agree and second your motion on that aspect. But joking aside, I have Representative Drinkwater, followed by Representative Cuddy, followed by Representative Warren.
Thank you, Madam Chair. Seeing as how I am related to this bill, I would like to second her motion for the extra 500,000. I would also like to encourage Maine Housing to find a funding mechanism where they could fund this through some type of fee that they would supply the ongoing money so that we don't have to go to the general fund as we are now. Obviously, we are on the precipice of saying PFAS has contaminated a tremendous amount of wells. Having had personal experience with the Plymouth waste oil site, there cannot be enough money put towards this. Obviously, the DEP right now is investigating PFAS, but we need the money to say remediation. Now, obviously, this is one step towards a bigger picture, but I would absolutely agree that we need to throw more money at this because we are in a situation where there's going to be a lot of problems. So thank you, Madam Chair, and that's my statement.
Thank you, Mr. Drinkwater. Nice allusion there. With that, Representative Cuddy, followed by Representative Sylvester, followed by Representative Bradstreet, followed by Representative Prescott.
Thank you, Senator. And thank you, Senator Guerin, for that motion. I mean, my district is hit hard by arsenic in the wells. And I had conversations with folks who were supportive of the bill around PFAS, because what we heard from testimony around the expense of testing for PFAS and remediating that it's a big need, and the $500,000 doesn't really address that. But there are other funding sources that are addressing PFAS as well. I love the amendment. My sole concern is, as we all know, the more money you put to a bill, the more difficult it is to get it through appropriations and financial affairs. So I'm not, I feel like if we can get a unanimous vote out of the committee, that increases the chances certainly of it getting through. But I really want to see money appropriated this year for this fund, because people in my district really need this.
Thank you, and agreed, Representative Cuddy. I have Representative Sylvester, and then Bradstreet and Prescott.
Thank you, Madam Chair. So a couple things. One, I just wanted to let folks know that I had one of those concept drafts that we've been talking about that's a housing bill. But after the arsenic bill, I did a lot of research, looked at what was out there in terms of people being able to get testing. So I do have a concept draft coming forward that will also provide money for people to be able to get a test for PFAS on their land at the point of sale, which is really the part that we can direct here. So that's forthcoming. But I also agree that we probably need more money for this. It's something we're going to see as people become more aware of it. And I wonder if we want to think about putting some, or directing Maine Housing to use some of the administrative money if it's going unused to make sure that people know about the program.
Good idea and good question. I don't know if we have anyone from Maine Housing with us, but at least that's something we can consider. Representative Bradstreet.
Thank you, Madam Chair. Yeah, I'm sitting here in my neighborhood and I'm looking at 6 or 7 different homes, and I know some of them, my own included, has been affected by arsenic levels. So I'd be fully in support of the amendment, and certainly in support of the original bill too. I just kind of urging Maine Housing, when they dispense the monies, to look at point of use remediation whenever possible, instead of whole house remediation, because I know whole house would be better, but it's a lot more expensive, and we can reach a lot more people by using point of use remediation wherever we can. Thank you.
Thank you, Representative Bradstreet. Representative Prescott.
Thank you. I just want to make sure I understand Representative Drinkwater's amendment. Was the intent of that, after this $1 million is exhausted, Department of Housing will look to continue this program using existing funds, something already within their programs, instead of adding additional fees? Is that what that was supposed to be?
Anyone care to respond to that? Representative Drinkwater, is that what you're raising your hand for?
Yes, Madam Chair.
Please jump in.
My intent is to find a funding mechanism that doesn't automatically run to the general fund every time it needs to be replenished. So I'd like to see the Maine State Housing look to some type of internal funding source. Now, I'll give you an example. In my area, we have city sewer. Every time somebody hooks up to it, there's an impact fee. And I know City Bangor is the same way. So I would like to encourage us to find a funding source to keep this money flowing internally instead of running to the general fund every time. So that's my intent.
Thank you.
I have Representative Cuddy, followed by, just Representative Cuddy.
Thank you, Senator. I looked at the participants list and I couldn't see anybody from Maine Housing on either, which is unfortunate, because part of my understanding was that $500,000 funds this program for multiple years. And does Maine State Housing have the capacity, with the way they are currently set up, to do more in the next couple of years if they have $1 million? Or is that just going to, and I shouldn't say just, is that going to fund the program then for 4 years instead of 2, or 6 years instead of 3? Because obviously the ideal is to help more people in the next couple of years, as opposed to helping people out over a longer period of time. So I was interested to get that information from Maine State Housing, but I can't see anybody in the participants list.
I'm wondering actually if we can have the bill's sponsor join us. I do think she's with us, Representative Fay. I don't know if you want to weigh in because I know you've been working with Maine Housing and obviously on this bill. So would love your thoughts on that.
Sure. Thank you, Senator Daughtry and members of the Labor and Housing Committee. And I am greatly appreciative to Senator Guerin for her motion. I just want to clarify a couple of things and give the committee a little bit more information about what's happening with PFAS in particular, and also remind the committee that the bill is for arsenic and other contaminants. So it's not just limited to arsenic or PFAS. There may be other contaminants that are covered as well. So that's the first point. The second point is there's a lot going on with PFAS right now, and the landscape is changing. I think in terms of arsenic mitigation, we're pretty settled in terms of what that mitigation looks like and what the cost and how that's done. The thing with PFAS is that it's still a little bit of a moving target. And I think the technology is improving. I think the costs are shifting. And I think DEP as well as others are doing a lot of work in this space. I'm hoping that we can keep the current program as it is because it's working pretty well. And then maybe, think about evolving a little bit down the line as we have more information about PFAS. And there may be, Representative Drinkwater, some additional funding and fee streams coming down the line. I don't know for sure what those are, but I do know that those are being explored currently in a number of other both, I think, committees and at the departmental level. So I just wanted to clarify some of that. And I think right now, as we've said, trying to think of when the program was implemented. It was originally funded with, I think, $700,000, and we're now down to $93,000. And the expenditures have lasted, I'm not even going to guess because I really need to look up the date of implementation up. So I think you can get a good sense of how long the money lasts. I think it'll be a couple years for now. And then hopefully we'll be able to find some other ways to help fund PFAS mitigation in Maine.
Thank you.
Hope that's helpful to the committee.
That is very helpful. Thank you. Representative Sylvester?
Thank you, Madam Chair. So a couple of things. One is there is a bill that was just heard in tax the other day that would take the retail transfer tax and send all of that over to Maine State Housing in order to fund their various programs for affordability and et cetera. So if you're looking for Maine State Housing to get more funding, that is one avenue to do that. Right now it's used in a lot of different ways. And then I guess I'm just sort of wondering, we all seem sort of supportive of the bill going forward. We've seen the amendment. I guess I'm wondering, is there anything else that people feel that we need to add to this before we vote on it? Or is there any part anyone's unclear about? Just to sort of move the discussion a little bit past, we support folks not drinking arsenic.
I think that's a noble agreement on all of our parts. I do have Representative Prescott and Representative Warren. Additionally, I do see Laura Harper has her hand up. So Laura, we will pivot to you once we have the committee members' questions addressed. Representative Prescott?
All right, thank you. This program was originally funded in 2017, and I think it was 500,000, as I recall. So they've done very well. We're now 5 years later. So if we allocate this $1 million, we're looking at funding this program for at least the next 10 years. I would think in that time, Department of Housing can figure out how to keep this program going without being funded by legislation. Thank you.
Thank you. Representative Warren? Representative Warren, are you with there?
Hello?
Now?
Oh, hey, thank you. So I wanted to ask about if there was some way to amend the language, only because I'm wondering, as the technology advances, if this testing is already happening, it would seem almost like we're doubling two different departments' work, like we're entering into some kind of silo. And if it were possible to streamline, make more efficient, and do PFAS intervention while doing this, that would almost seem, I don't know, it just seems like that would make sense if it's possible, or if it becomes possible. I don't know if there's some way to say, all for this specifically, if PFAS testing, can be integrated, that can be, funds can go in part to that. If there's some way to like make quite specifically clear that only PFAS would be allowed to be added to that as part of the funding mechanism, because of how much funding this would be over such a long period of time. I would just hate to see, different departments working in silos and, the same well needing to be tested over many years. I don't know, I hope that makes sense, but that would be the only change I would be interested in if we're changing the amount of funding this much. This would be great.
I think Representative Warren, I'm a bit confused as your concern about saying, because I think the language is fairly clear about the contaminants. And I just want to make sure we're not shooting ourselves in the foot by limiting it, if that makes sense. But I may have misunderstood you.
No, I want to expand it to say that I think that there was some mention that this is almost like not primarily for PFAS. But if the technology advances, or if they figure out what's going on and where this contamination is happening, or, I guess those details that Representative Fay was speaking about, saying that that element of testing was something that the DEP was in charge of or focused on. It seems like we should be being more efficient if we're already going to be there and testing it. Maybe fine, we're all set, but it would be great if actually there could be more communication or working together on this, if it's not happening.
I do think we have representatives. I do see Eric Jorgensen has been able to join us from Maine Housing, but before we shift over there, I did see Representative Morris has his hand up, but hopefully Representative Warren, we can get you some answers on that. Representative Morris?
Yes, thank you, Madam Chair. I would say that I certainly do support the amendment, and in regards to any future funding and so forth as it relates to PFAS and so forth. I think I'm sure there will be some sort of pending litigation on that front, and I would say that if there is any settlement forthcoming, that part of that money, I would suggest at that point we try to work on getting some of that money into this program going forward to help people with not just PFAS, but all of the various different issues that arise with wells. I know in my line of work, I see it regularly. As I know last week when Representative Sylvester asked a question on testing and so forth, that you are allowed to ask for a test prior to making a real estate transaction. However, there is no requirement that the seller do anything for you. Also, many types of financing will not allow you to close on a house without mitigating it. And it's also very difficult to find any sort of source. So I would also agree with Representative Sylvester's point about trying to make sure this program is known to people in that circumstance, so that nobody ends up losing out on a transaction when the time comes. So those would be my comments.
Definitely, and absolutely agree about, there's definitely going to be a reality of pending litigation. And I would say, as far as the language in this bill, if we're considering amending it, we want to, I think there already is language about, outside funding sources, but that's a pretty common, way that we can also revisit it once it's gone through. But absolutely. Got trying to think of how best to do this. I think Laura Harper and Sarah Woodbury, if either of you wanted to jump in and answer those questions. I think we're going to transition to Representative Gear, and then Mr. Jorgensen has been able to join us, and I want to make sure we give him a chance to speak. So, Ms. Harper?
Thank you so much. I really appreciate it. And I am loving this conversation about this bill. I really appreciate Senator Garrett's amendment of that funding. One thing I did want to flag that I was concerned about the second part of her amendment was lowering the allowable percentage for administrative costs. I noted in the memo from Maine State Housing Authority that they said that current law allows them to send up to 15%. They spent around 10% over the last 5 years. So if we are going to increase the funding, which is great, I just want to be sure that they have the allowable amount they need to administer the program. But I see the Honorable Eric Jorgensen is here now, so I don't want to speak for Maine State Housing Authority either, but I just wanted to raise that flag with you all about that administrative piece. So thank you.
Of course. Thank you, Ms. Harper.
And if I could just, sorry, I was going to address the PFAS thing really quickly because I know there's a lot of confusion around what's being covered and what's being not. So first off, the way that the language is drafted is it is meant to address arsenic and other contaminants. PFAS is considered, because of legislation that was passed last session, considered a contaminant in drinking water. The tests for the arsenic and radon and uranium and all of that stuff and tests for PFAS are two different tests. The PFAS one is more expensive. However, in terms of testing, HHS does provide free well water testing for low-income Mainers. So there is that ability for people to get their wells tested for the arsenic and the other stuff. For PFAS, DEP has a pool of money right now, which they are utilizing for PFAS testing and remediation. I think I mentioned in my previous testimony that this is not a sum of money that is forever. So I do think it is important for Maine State Housing to have the ability to remediate for PFAS. However, that's not an immediate concern. It's probably not a concern for a couple of years. The arsenic and the uranium and all of that stuff at this point is the bigger concern. I will also mention that when this legislation was first passed, Maine State Housing, the only thing they were paying for remediation for was arsenic. There was some miscommunication about what the original bill did. So they were not paying for remediation for other things like radon, lead, uranium, and that will be done going forward. So that will increase the amount of people that need to be helped going forward, even irregardless of the PFAS thing. And then when we get to the PFAS thing, DEP is currently, if you test your water, it tests positive for PFAS, DEP will refund you the money for the test. And they will help you get remediation. Like I said, that is not a permanent thing. They've got about $20 million. I'm sure everybody has seen the news. That money is going to be gone through relatively quickly. And so down the line, it is possible that for low-income Mainers, this fund will be a lifesaver. I just want to make sure people are aware that that is probably not for a couple of years, but I think the $1 million is a great idea. And we're fully supportive of that because of the fact that the program previously was only treating for arsenic. And there are other contaminants that people have in their wells that have not been treated for, like I said, uranium, lead, radon, all of those awful things that can also be now taken up with this funding. So.
Thank you, Ms. Woodbury. That's very helpful. Representative Gear, did you want to respond to that, or should we kick it over to Eric Jorgensen and circle back?
I would say kick it over to Mr. Jorgensen and circle back. I want to hear from him first.
Wonderful. Well, welcome, Mr. Jorgensen. Lovely to have you before us. I know you're joining us late, but we've had some questions about Maine Housing and the role, so I don't know if there's anything.
Yeah. Thank you very much. I was stuck on the YouTube and so I was listening, but I wasn't able to get in. So I was sort of waving my hands at the screen, and I'm glad I started sending out texts, and Representative Pedworth actually rescued me. So I appreciate that. I guess the main thing is, I think Sarah Woodbury just said it all really well. This is money that we have been treating for arsenic in the past and other things that get fixed by adding a house filter or a point of source filter. And so to the extent that PFAS can be covered by that, we certainly could do that as well. I think, as has been noted, though, I do think that this is I think that PFAS is like a whole new thing. And I don't necessarily want to come out and try to say that this program will work perfectly for that in this current form. As she said, we're going to be getting some, we will be getting a broader list of concerns that these filters would take care of under this bill. We're very happy to do that. I think we could certainly handle going up to $1 million on this. We would direct it to that. With regards to the issue of administrative cost, we have managed to keep it under the amount that's available to us just because we've been able to find other funding available. But I would not want to necessarily see our funding for administrative costs limited. We will certainly be as frugal as possible. But I think we do need to have the ability to get a reasonable amount of administrative overhead out of that if necessary. I mean, we try to find other sources and general fund money for that kind of thing, and would prefer to put the money all toward people that are, applying for our services. So, but it's hard to predict now because, this will be probably more people coming through the program with the additional list of hazards that this will be covering, and PFAS is is part of that as well, and that's probably going to be a growing concern too as we go forward. So, it's a little bit ambiguous at this point. And I apologize for not having a stronger or clearer answer, but we'll certainly work with the committee and with the sponsor and with others to make sure that the bill is that we carry out to the best of our ability what this bill is trying to do.
Thank you very much, Mr. Jorgensen. I think one thing that we're all clear on, it sounds like, is the need to move, this forward and make a difference on this. Representative Gear.
Thank you, Madam Chair, and thanks to Mr. Jorgensen and Ms. Woodbury for all of the clarifying information. Much appreciated. I'm with Representative Warren in that I hate silos because silos create inefficiency and cost. And I think we all share on this committee a desire to have as much of the funding as possible go to actual testing and remediation so that people can have safe drinking water. So that said, I guess two questions that I have. One is, from the standpoint of PFAS today, it sounds like the DEP is doing that testing. How does someone find out about the availability of their wells to get tested from the DEP? And then and I'm happy to make an amendment on the second thing, can we trigger some sort of process or communication that would happen between DEP and Maine Housing, where, for example, if someone is concerned about PFAS and gets their well tested from the DEP, can we, connect that with testing generally that would also identify for the other contaminants under this program? I guess I just don't want this to get down the line and find out, in a year or two that, gee, we tested them for PFAS and did something there, but while they also have arsenic. Can we do that all at once somehow with this bill? Thank you.
Thank you, Representative Gear. I have Representative Warren, followed by Representative Morris. Representative Warren, are you able to join us?
Hello. I just I wanted to say to Representative Gear's point, that's what I was trying to get at earlier. So I apologize. I didn't communicate it well, but it seems like that ought to happen. And I don't know why it wouldn't happen. And I'm wondering what what barriers need to be overcome to make that the case. I'm really would be confused about that. And it would seem like it ought to be done.
Is there anyone here who could answer that? Ms. Woodbury?
Yeah, so one thing, the tests for arsenic and other contaminants are completely different than the test for PFAS. We can test for arsenic and other contaminants through the state lab. We cannot do that for PFAS. Maine does not currently have a PFAS testing facility. We have to send all of our PFAS testing out of state. I believe there is some funding within the current budget that the governor is going to put forth that would set up a testing facility here in the state of Maine, but we don't currently have one. So that their pass for the testing for PFAS is more expensive. It's harder. You have to test for a certain number of contaminants. It's a whole thing. And in terms, so it's hard to do them at the same time because it's not the same test like it is with other contaminants. And we just don't have the capabilities here in the state to do that currently. In terms of how people know that they should test their wells for PFAS, a couple of things. Currently right now, and I'm sorry for all the like info dump, but like DEP is in the process. I'm sure people have seen the news about the farms that need to be tested. So what happens is DEP has a list of sites where contaminated sludge has been spread on farms across the state. They go to that site, they test that site. If that site tests high, then they start testing out in concentric circles. They start a half a mile out. If that's high, they go a mile out. If that's high, they go a mile and a half out. And so that's how they test the water, I should say. So that's how folks are getting tested for PFAS. There is not some sort of process for people to get notified that they need to do it. If you are on a public water system, or if you are a school or a daycare that is in a non-community, non-transient water system, the state is testing all of those. So if you're on a public water system, you don't really need to worry, which is also the case for arsenic and stuff. If your school or your daycare is on a well or a community water system, the state will also be testing all of those. In terms of just the general public wanting to get tested for PFAS, there's not, I mean, you can do that. You can reach out to the state. There are public or private facilities that will do that. You would just have to pay up front for that yourself. And then if your well came back and said it was high for PFAS, you could let the DEP know and they would reimburse you. If it comes back not high for PFAS, you've kind of eaten that $350. So that's kind of where we're at in the PFAS testing world for drinking water.
Good to know. Thank you. Representative Warren, did I see your hand up for a follow-up?
Yes, I did. Thank you so much. So I guess I understand that there's a massively different cost and these sorts of issues. Again, this may just be getting a bit in the weeds, but it seems important if we're going to potentially allocate this amount of money over that long time, which is, again, sounds like a great thing to do. It would seem that just an issue again and again with some of these longer term like renovation or testing type issues. Labor is one of the biggest issues we've got, and with this massive shortage. So over such a long period of time that it would seem like if you've got someone who is qualified to go out to a house and test a well, that sure on the back end, going and sending the test in two different directions, so that seems like much less of an issue than literally just, having a qualified person be able to go and physically be there. Even just saving on gas and having a working person be able to be at the house if they need to be when you show up to do the testing. And so it just does seem like still, I get that it's a much bigger cost and et cetera, but if we begin to, even if it's into the future, it would seem that at some point these two tests should be integrated together and done by one person. And I also I don't like the idea of saying, your well is clean and good, but really it's just, oh, we didn't test your water to see if it was clean fully, just because it was more expensive at this time. We can't tell you that you've got a clean well, really, which I think is part of what we're saying, just because it's way more expensive. So I understand that element of it. We live in whatever. Anyways, it just still seems like, if you've got a body going out to do that work, it could be done. It's just the cost of the test.
Representative Warren, I absolutely agree about needing to break down the silos. I'm wondering, I think you may have just found an idea for an excellent new piece of legislation, because it's a great point. Wondering if it's maybe something we want to take up as part of another vehicle, and not with the existing program, or potentially maybe have a letter coming from the committee asking for more information and ways to maybe break down those inefficiencies and find a way to move forward. I do want to kick it over to Representative Morris, who I know has had his hand up patiently.
Yes, thank you, Madam Chair. Actually, I had a question for Ms. Woodbury on some of her. I thank her for the information. I do know, as I said, being a realtor, I know enough about this just to be dangerous. But the issue I know on some of the testing, I know with like traditional testing, because we usually use private labs to do it. And so you can usually test for all that other stuff. So it's good information to know that they can't test for the PFAS at the same time. But my question on the PFAS issue is it, have they, in terms of if she knows, in the course of testing some of these wells and some of these water, the private wells in particular, is it generally found more in groundwater, or has it been found in all wells, regardless of whether it's a drilled well or a dug well water source? Is there, I would imagine to be found in the dug well, but I don't know if it's as common, if it can get to that level with a drilled well.
I don't actually know the answer to that question. I know that, so for the Tozier farm in Fairfield, they spread the sludge on their farmland and it kind of leached out to all of the folks around them. But I don't know if those are drilled wells or dug wells or what. I'm not sure it actually matters.
Yeah, no,
because the
it
contamination comes from
it's more of a question from the standpoint of, is it, obviously it would be found in a dug well, but the reason I ask is that I know that like things like arsenic and radon are usually not found in groundwater.
PFAS can be, because of the way it's contaminated.
Okay, I just didn't know if it could, because usually, obviously, when you're drilling for a well, you're having to, it's because you need to get more water. So I didn't know if it could seep. And I'm sure it's like anything else. You may have one neighbor that has a high contamination and the guy next door has absolutely nothing. That I'm sure has happened too.
Yes, that's correct. But it's because of the way I don't think it matters either way, just because of the way the contamination. It happens in groundwater. We're contaminated from sludge, from AFFF firefighting foam has gotten into surface water. There's just the way that it's contaminated that does the contamination. Unfortunately, I don't think anybody's safe. So
no, I figured as much. I just was curious on that point.
Thank you, Representative Morris. I had Representative Gear, who I do believe has come up with a proposed amendment that she's placed into the chat. And then I have Representative Warren.
Thank you, Madam Chair. Yeah, I did put a proposed amendment in the chat that basically would, I think, address the fact that we aren't quite there yet with the PFAS testing, which I understand. But I think we could take advantage of the opportunity, as I said, with permission of the property owner, Maine Housing, and or to Ms. Woodbury's point, DHHS and DEP would share information on tested properties and provide the ability to the property owner to add the test, the other test, whatever the other test would be, to the visit. Back to the point about efficiency and making sure that folks are, when they're testing their well, if they're not just testing for one thing, so they can make sure that well is safe from all contaminants. So.
Any thoughts on that? Representative Warren?
I do really appreciate that concept. I guess I'm wondering, is there some way, or is this the intention of the amendment, Representative here, to say that if you've got a DEP, staff or a contractor going out to do this for low-income family, could they also do this HHS test at the same time? Like, is there some way just to not have two different workers having to drive out and do it? Does that make sense? I think, like, if we're going to be ramping this up, if we're going to be appropriating the amount of funds, it would seem like that as much crossover as possible.
Yeah, that was definitely the intent of the amendment, was to create a process that they would share the information. And I think it still needs to be up to the homeowner. But I see Mr. Jorgensen's waving his hand. Sorry, Madam Chair, didn't mean to.
Jorgensen.
Thank you. My understanding is we don't do the testing. We have referrals from people who provide the testing. So I think that information would be great in principle, but I just don't, I don't believe this appropriation would pay for testing. Isn't that correct?
I would defer to the bill sponsor. I'm getting some thumbs up. So Representative Fay, did you want to add in there?
Yes, no, this is for mitigation. So the testing happens and thank you, Madam Chair. And I think your suggestion to Representative Warren is a good one. We have drinking water quality and access to clean water housed in several different departments. We have the drinking water program in DHHS, and then DEP works closely with them, particularly on this PFAS issue. I think that is a larger conversation than this bill contemplates. And my concern is that, primarily the goal is to make sure that Maine Housing has the funds that they can, that they need in order to make sure that folks who have been through these testing programs in various ways and find out that they have contamination can afford to mitigate that contamination. And it really is as simple as that. I think this is a really important discussion. And, I'd be happy to work with Representative Warren, having served on DEP and having spent a lot of time thinking about clean water and drinking water, on what a new, what a partnership would look like that is codified, that makes it easier for folks to access this testing. But I think that's and forgive me, I think it might be outside the scope of what Maine Housing is doing in this program.
Thank you, Representative Fay. I have Senator Guerin.
Thank you, Madam Chair. And thank you, Representative Fay. You really got to the points that I was going to make. I think Representative Geer, perhaps you can work with Representative Warren on a bill that would deal with the questions you're asking, but this bill is really about mitigation and fixing the problems that have already been discovered or as they're discovered. So I would like to stick with the cleaner version of the bill.
Thank you. I have Representative Bradstreet.
I thank you, Madam Chair. Yeah, I appreciate pointing out that, a lot of communication does need to happen among different departments, especially in something like this. We've already heard from the Maine State Housing that they're not directly involved, and yet the proposal also includes DEP, and we're not sure how they would be involved either. So I think I would agree with Senator Guerin that they seek perhaps another bill to take care of that situation if necessary. And I also like to point out that we are getting a little bit far away from the proposal listed in the bill, and that's to provide funding purely and simply. And that's what I'd like to address. Thank you.
Representative Bradstreet. I have Representative Sylvester.
Thank you. I just echo Representative Bradstreet in terms of, the scope of this bill. And just to remind folks that, again, I have another vehicle coming forward for just this reason, is that I could think of 10 other things that might be addressed regarding PFAS and other chemicals found. And so that regarding testing specifically. So and the costs of testing. So just sort of throw that out there, and that we're definitely going to get another bite of the apple here coming up a week, 10 days.
Representative Warren.
No, I appreciate this all. It's just because of how much more money we're talking about and how efficient, frankly, this program is, how long that funding could be projected to last. It does seem that, money talks when it comes to a lot of things about state government. And I just think like us having the opportunity to have this conversation is potentially not going to come up for quite a bit of time if we allocate this amount of funding this way. So I guess that's what really inspired me to be pushing on this. I understand it is or seems unrelated or, far afield, which I'm quite ignorant, quite new to a lot of this stuff. So very, very extremely possible, more than likely. But in my mind, I found it being connected. So, but appreciate everyone's time and patience with me on this. I'm happy to work with, of course, we've honored to work with Representative Gear in the future, but just the amount of funding was my issue around it, I guess, which I do appreciate.
Thank you, Representative Warren. So I think we've sort of all coalesced around an agreement that there's a lot to do and a lot of efficiencies we'd like to increase. But it does seem, from everything I'm hearing from the committee, we sort of coalesced around the idea that Senator Guerin started the conversation with the increased allocation. I know she didn't make a formal motion, so I'm wondering if anyone at this time would be willing to do so. I don't know, Senator Guerin, I see your video come on, so.
There you go. I would like to move ought to pass on this bill with the amendment that we increase the funding to $1 million. And after hearing Representative Jorgensen, I would go back to what they said it was costing about 10%. So with the 10%, and hopefully efficiencies can be added to that to lower that amount, but with the 10% administrative fees.
I'm seeing a nod from Representative Jorgensen. Man, old habits die hard. Eric, seeing nodding with that. Do I have a second for Senator Guerin's motion? I have a second from Representative Rader. Do I have any other questions, clarifications, thoughts, feelings on the motion before us? Seeing none, in the interest of lunchtime, Justin, would you please call the roll?
Senator Daughtry.
An enthusiastic yay.
Senator Daughtry, yay. Senator Guerin.
Yes.
Senator Guerin, yes. Senator Hickman. Senator Hickman is absent. Representative Sylvester.
Yes.
Representative Sylvester, yes. Representative Bradstreet.
Yes.
Representative Bradstreet, yes. Representative Cuddy. Representative Cuddy is absent. Representative Drinkwater.
Yay.
Representative Drinkwater, yay. Representative Gear.
Yes.
Representative Gear, yes. Representative Morris.
Yes.
Representative Morris, yes. Representative Pebworth.
Yes.
Representative Pebworth, yes. Representative Prescott.
Yes.
Representative Prescott, yes. Representative Rader.
Yes.
Representative Rader, yes. Representative Warren.
Yes.
Representative Warren, yes. So we have 11 in favor, 2 absent.
Thank you, Justin. That is unanimous of those present and voting. So huge thank you to the bill's sponsor and Mr. Jorgensen, and as well as to Ms. Woodbury and Ms. Harper for helping us throughout this process. Thank you. Now, I'm going to close LD 1891. And up next, I'm going to open the work session on LD 1922, an act to amend certain laws pertaining to the Maine Public Employees Retirement System from our own Representative Sylvester. And I'll kick it over to Steve for the analysis.
Sure. So this bill makes the following changes to the laws governing the retirement system. It removes the provision that provides that the service retirement benefit of a judge ceases upon the return to service as a judge, and that a judge returned to service continues to earn credit toward retirement. It corrects a cross-reference in the law that governs ordinary death benefits for members in the judicial retirement program. It clarifies the definition of qualifying member for the judicial retirement program to include retirees who receive a disability retirement benefit in change to service retirement. It clarifies that actuarial equivalent calculations are based on the discount rate assumption adopted by the Board of Trustees of MainePERS. It changes references to School Management and Leadership Center to Education Service Center in accordance with changes made in Public Law 2019, Chapter 219. It clarifies jurisdiction over administrative decisions on membership. It specifies the types of retirement plans that the Board of Trustees may establish and offer. It makes changes to language regarding disability retirement related information that is reported by the system annually to the legislature. It aligns the provisions for automatic refunds on inactive accounts with federal law. It deletes a cross-reference to inapplicable federal law in the military service credit purchase provision. It removes the ability for certain retired participating local district members who are restored to service to re-enter the plan in order to bring the provisions into compliance with federal law. It clarifies the required minimum contribution rate that participating local district employees must contribute to a defined contribution or deferred compensation plan in order for it to be considered a qualified replacement plan. It permits the Chief Executive Officer of Maine PERS to adopt a remote meeting policy for the participating local district advisory committee. It incorporates a change in title from Executive Director of Maine PERS to Chief Executive Officer of Maine PERS and directs the reviser of statutes to incorporate this change throughout the statutes. And it removes obsolete, unclear, or inconsistent language. Senator Hickman had me forward a proposed amendment for LD 1922. So upon enactment of some special retirement plans, one, for those of you who have been on the committee might remember LD 1480 from the 128th legislature. It created a special plan for fire marshal investigators and fire marshal sergeants. So sometimes when a special retirement plan is created, some members can actually be a little bit at a disadvantage when their position moves from one special plan to another. The proposed amendment from Senator Hickman specifies that a member whose position is moved from one special plan to another special plan can retire under that former special plan if the member has met the eligibility requirements for retirement under that plan. Maine PERS actually drafted the language and has indicated to Senator Hickman that it's open to having this included as an amendment to LD 1922. Another amendment that was proposed in public hearing was from William Lobenstein. He proposed adding a retired member of the retirement system who is appointed by the governing body of the Maine Association of Retirees, which is the organization that he represents, to the Maine PERS Board of Trustees. The committee sought additional information on sections 11 and 12 of the bill, and I did follow up with that information from Ms. Moran, who's also with us today on February 7th. We don't yet have a preliminary fiscal impact statement.
Thank you so much. Any questions? Any thoughts? Representative Sylvester?
I would see Senator Hickman's amendment as a friendly amendment. I would include the suggestion for the, I'm so hungry, I can't remember the name of the group, although I talk to this group fairly regularly. The Maine retirees group that testified in the line that talks about a retired person, to say that it would come as a suggestion either from that group or another group of retirees. So just to mention them specifically as a group that would be consulted. And then, and so those are my two friendly things. I think that the other piece of discussion that has come forward, and I know we're all hungry, is whether or not we get enough reporting from Maine state retirement system, whether there is something, whether we want to add anything, information that we get right now, or to have it more frequently than we get it right now. So I wonder, Steve, if you could just review for us again the information that we get from the Maine retirement system, or we could move to Ms. Moran if that's easier.
Yeah, that's probably best. She did follow up sort of with what that change is. So I'm happy to defer to her in terms of what their reporting requirements are, as I am also new to staffing the committee.
Perfect. I've asked Ms. Moran to be able to join us. Ms. Moran?
Thank you. So are you asking Representative Sylvester the question in the context of just the disability requirements, or in terms of the report in general, what we report to you?
I think on both, right? I mean, those are the questions that I've gotten from folks, is what, are we getting enough information? And so I wonder if we could just start with a review of what information we are currently getting. You know, then that would be probably how I'd want to deal with that, to see if any members thought there was something else that you have information available that you could give to us.
Sure.
and how often we get it.
Sure. I don't know if it would be helpful, Steve, if you pull up the statute that has to do with our report to the legislature. So we're currently working on a report that's due to you by March 1st. The sections in this bill are embedded in that section of statute in terms of what we report. But the statute currently is sets forth what we report to you very specifically. And Steve, can you bring that up or not? I don't want to. I could read it to you if that would be helpful. It's a pretty long list of things that we report. They're mostly policy and administration issues. Any legislation that we would recommend that you would support, a review of the operations of the retirement system, including summary of admin expenses and improvements and delivery services, that sort of thing, budget information, numbers of individuals who retired, numbers of active, a lot of demographic information, how many members there are, how many retirees there are, those who have been added to the plan, for example, information about the investment program, information about employee and employer contributions that we receive, information specific to the disability program, including things like how many people have applied for disability and how many were awarded benefits. There's a separate table that we provide to you in this report that sets out all that data for you to see kind of the flow of applications, how many people are awarded, how many people are denied, how many people appeal, how many people are awarded benefits after an appeal, that sort of thing. So there's a table of information that we provide specific to the disability program, which extends into the appeal program, because most of the appeals that we receive are from the disability program. We provide you with information about the defined contribution plans that we administer. So it's a comprehensive operations report that tells you about what we're about, and including any specific data that you've asked for.
And how often do we get that?
Annually. So that's a report that by statute we provide to you by March 1st of each year.
I get a lot of different pieces of information from different folks about how often we got that. And is there a bigger review that happens on some other multi-year?
Right. So the other review, which you're going to, I think, talk about today, is the Program Evaluation Act review. And that's an every 8-year cycle by statute. That's under the government evaluation program. That's not in Maine PERS law. That's a cycle that I believe applies to most agencies. It's set out in statute in terms of how frequently the agencies are reviewed. So we submitted that report back in November. We presented it to you early in the session. And I believe on the agenda today is some discussion about your output of that on that report. So that's an every 8-year report.
Excellent. Thank you. I just wanted to make sure everybody heard that, both of those things at home. Thank you so much.
You're welcome.
Representative Gear. And thank you, Ms. Moran.
Thank you.
Thank you, Ms. Moran. And I also want to give a shout out to Steve Langwin for the depth of all of the analyses he's provided today. It's been very helpful. My question follows right along with what we were just discussing and what you were talking about, Ms. Moran, which is, I think I was certainly encouraged by Dr. Wyke, is that her new name? Sorry. And the change management initiative that she has begun at Maine PERS. And I think that's a super important effort that we need to be tracking in order to see the results that it's having for Maine folks who are working and also using Maine PERS for their services. So 2 questions I have in that regard. One is that, are there any measures currently around customer experience and customer service satisfaction and employee experience and employee satisfaction in either of those reporting efforts that you mentioned, Ms. Moran? And if not, I would like to make a motion to amend this bill to add those. So do they exist currently, Ms. Moran?
We are currently in our strategic planning work, working on exactly those things, putting together things like surveys for our membership, for our employers, for the people that we serve, so that we can get that kind of feedback from people. We're also working with employee surveys to gather information in the context of our strategic planning. Dr. White talked a lot about this, I think, when we presented the GEA report in her overview of the system a month or so ago. We have started the work, the initiative with strategic planning with our staff, and we have scheduled a number of meetings with our staff to get their input on the organization and the culture of the organization and the goals and values and that sort of thing in the context of our strategic plan work that we're doing. So those are things that are certainly underway right now.
Thank you. And that said, I would offer to the committee, I would like to propose an amendment to this bill that would provide, in the context of the annual report that Ms. Moran mentioned, that Maine PERS provides a measure of customer satisfaction and customer experience based on survey research, and that also in that report is the same type of measurement of employee satisfaction and employee experience that would line up with the efforts of the strategic planning initiative.
I think that's an official motion.
I move that, yes.
Move that, okay. Do I have a second? Going once, going twice. And seconded by Representative Sylvester. We have a motion on the floor. I'm going to move to Representative Bradstreet.
Yes, thank you, Madam Chair. Thank you, Ms. Moran, for being here. I'm looking at the second page of your testimony. It says previously indicated other sections of the proposed bill not specifically mentioned in this testimony make non-substantive changes to retirement laws. The proposed amendment, would that be a substantive change in your mind?
The amendment just offered by Representative Gear?
No, excuse me. The amendment, I think it was initiated by Senator Hickman. Of the bill.
If it had been in the original bill, I think we would have talked about it as a substantive issue. We, as Steve mentioned, we actually provided that language. We identify, we recognize that the individual situation that was brought forward to Senator Hickman is kind of a unique situation, and it's not something I think that we run into typically when you institute a new special plan, a better special plan. Typically, people are benefited by that. And in this case, this was a brand new special plan, different requirements, and there was an individual who kind of was going to get caught in that. And so we certainly recognize that your intent when you're instituting special plans is to not have people harmed by those changes, which is why we worked with Senator Hickman on some language that we believe would accomplish that result without causing any costs to the plan, for example, or any concerns for the plan.
Okay, so it's no substantive change. It's just basically correcting something that maybe people thought was in there originally.
We believe it's a very member-friendly result, and we're always trying to head in that direction if we can do that in situations like this, so that we can address the specific circumstance of a person who kind of gets caught in a situation that was never, we don't believe was intended.
Okay, thank you. The only thing I'm concerned about, of course, and the reason I asked is kind of a mission creep. Sometimes those types of things happen inadvertently. Thank you.
Thank you.
Do you have any questions either for Ms. Moran or thoughts on the motion before us with amendments? I think everyone's dreaming of lunch. Senator Hickman.
The motion includes the amendment. I didn't hear the motion because I was on my other committee.
No worries. The motion includes your amendment as well as, I don't know, Representative Gear, if you'd like to clarify the friendly amendment that you put on it as well.
Sure. I moved to add in the annual report, Senator Hickman, the a measure of customer satisfaction and experience based on survey research, and a similar measure of employee satisfaction and experience based on survey research. I do believe that in any change management initiative and in any strategic initiative, you manage what you measure. And if we don't have clear metrics that will be reported out, I think that you can lose focus. So I want to make sure that that main person, all of the good work that it's doing to address these issues, has the ability to then measure the results and report out to us on an annual basis.
Thank you.
Thank you both. I'm not seeing any other hands jumping up. Oh, Representative Pepworth.
Sorry, thank you, Madam Chair. There was also a question about adding a retiree to the Board of Trustees. Is that part of our amendment as well?
I would look to the motion makers for clarification on that one. Representative Sylvester.
If Representative Gear is adding to my bill, then I put forward that amendment to include the name of that retiree group that testified, whom I'm still unable to come up with, but Steve, I know Steve knows what it is.
The Maine Association of Retirees. So are you adding a member, or are you clarifying that a member?
In the line where we already have a retiree member, I would like them to be listed specifically.
Okay, got it.
All right. Everyone clear? I'm seeing nods. I'm also seeing everyone getting the Zoom fatigue, feed me lunch face. So with that, I'm going to have Justin call the roll.
Senator Daughtry.
Yay.
Senator Daughtry, yay. Senator Gearin.
No.
Senator Gearin, no. Senator Hickman.
Yay.
Senator Hickman, yay. Representative Sylvester.
Yay.
Representative Sylvester, yay. Representative Bradstreet.
No.
Representative Bradstreet, no. Representative Cuddy. Representative Cuddy is absent. Representative Drinkwater.
Nay.
Representative Drinkwater, nay. Representative Gear.
Yes.
Representative Gear, yes. Representative Morris.
No.
Representative Morris, no. Representative Pebworth.
Yes.
Representative Pebworth, yes. Representative Prescott.
No.
Representative Prescott, no. Representative Rader.
Yes.
Representative Rader, yes. Representative Warren.
Yes.
Representative Warren, yes. So the motion is 8 in favor, 5 not in favor.
Thank you, Justin. Is there a minority report?
Ought not to pass.
So with that, the motion ought to pass as amended carries, and I will close the work session on LD 1922. At this time, I unfortunately have another bill to jump to, so I'm going to virtually pass the gavel over to my esteemed House Chair and hope you guys have one last bill. Can't get into too much trouble, right? But have a great weekend, everyone, and hopefully see you tomorrow in person. And with that, shift it over to Representative Sylvester.
Thank you, everybody. I will just facilitate on this as we're and not speak unless I'm asked a direct question, as it's my bill. Again, in favor of the department. So I open the work session on LD 1925. Resolve regarding legislative preview of portions of Chapter 9, rules governing administrative civil money penalties of labor law violations, a major substantive rule of the Department of Labor, Bureau of Labor Standards, and pass it over to Steve.
So this bill allows for legislative review of Chapter 9 in the Department of Labor, as Representative Sylvester indicated in the title. The proposed amendments clarify and expand upon the process for calculation of the penalties for wage and hour violations. Specifically, it adds multipliers for repeat and willful violations and provides for combining or grouping violations. The proposed rule expands upon the process for appeals of such penalties by explaining in more detail the conduct of an appeal hearing, the role of the hearing officer in conducting that hearing and issuing a recommended decision, the role of the Bureau Director in issuing a final agency decision, and the right to appeal to Superior Court. The proposed rule also adds definitions and explains the respective roles of the Division Director and the Bureau Director. I did attach to my bill analysis the proposed rule. because it's a major substantive rule, there are specific things defined in statute that the committee should consider upon its recommendation of whether the Department of Labor should be able to adopt the rule finally. I don't think that I need to go through them, but and there's no requirement that the committee itself go through each and every one of these, but it's just something to sort of keep in mind as you begin your discussions. We actually did, and I don't get to say this very often, but we did receive a preliminary fiscal impact statement saying that the cost can be absorbed and that if it were straight out to pass, there would be no fiscal note necessary. With that, I'm happy to try to answer any questions.
I am not seeing any hands up. I'll just summarize. I was just looking through the testimony. I didn't see anybody testified again opposed to this bill. And we saw testimony from the chamber, neither for nor against, but saying it would be a clarification. Am I missing anything?
Yep, no, that's my understanding. Yep.
Representative Drinkwater.
Thank you, sir. When was the last time, and maybe this is for Mr. Rowland, how long ago were these updated? Do these get updated every, say, 5 years or 10 years? When was the last time it was updated?
I think on the rule it says, it might say, let me try to pull it up. At the end it mentions.
And I see that Mr. Rowland is there. So while you're looking that
Yeah.
up, if Mr. Rowland has an answer for that question, if at the tip of his tongue.
I don't have a particular specific answer, but it's been a long time, I can tell you that.
Yeah, so I'm looking at,
Yeah.
yeah, I'm looking at the rule. The law that gave the authority for the rule was in 1999. The effective date of the rule was May 24th of 2002. So it's been almost 20 years.
Oh, wow. If I may follow up quickly.
Of course.
I expressed my concern last time on the ability of business owners to run to bankruptcy court and discharge fines and penalties. Was there any discussion behind the doors to say, yes, that's something we can fix that they can't hide from, or no, that's federal law and we can't change it?
And do you want me to answer that?
Whoever has the answer.
Yes,
that's
please.
who I'm
I was
looking
saying
forward
it on mute.
We have had experience with that. I think you asked in principle whether that was possible. It is. We have current experience and we've had past experience with employers who have avoided their responsibility by employing a bankruptcy proceeding. As far as I know, there is nothing that we can do to prevent that from happening, but we just have to wait it out and see what we can eventually accomplish after the bankruptcy is completed. Unfortunately.
All right, so my understanding is there's nothing this committee can do to prevent that from happening.
I think not, and I will check further, but as far as I know, there isn't.
Thank you.
And I think Representative Drinkwater, such a bill was put forward, it might go to judiciary and the bankruptcy laws rather than coming to us. So I'm not sure if that's one that we would have to have consultation on anyway, but it's a darn good thought, and I encourage you to explore that and try and figure out a solution to that, because that would be a great solution for workers and employers who are doing the right thing. Are there any other questions for either Director Rowland or for Steve? Seeing none, I would accept a motion. Representative Gear. Representative Gear.
I move ought to pass.
There is a motion of ought to pass. Is there a second? Second from Representative Pebworth. Is there any further discussion? Seeing none, Mr. Purvis, if you would call the roll.
Senator Daughtry is absent, so we'll start with Senator Gearin.
No.
Senator Gearin, no. Senator Hickman? Senator Hickman is absent. Representative Sylvester?
Yes.
Representative Sylvester, yes. Representative Bradstreet?
No.
Representative Bradstreet, no. Representative Cuddy is absent. Representative Drinkwater?
Nay.
Representative Drinkwater, nay. Representative Gear?
Yes.
Yes. Representative Gears, yes. Representative Morris?
No.
Representative Morris is no. Representative Pebworth?
Yes.
Representative Pebworth is yes. Representative Prescott?
No.
Representative Prescott is no. Representative Rader?
Yes.
Representative Rader is yes. Representative Warren?
Yes.
Representative Warren is yes. So we have 5 in favor, 5 not in favor, 3 absent.
So the motion as stands, awaiting other absentee votes, is 5-5. And I would close the hearing on LD 1925. And that, folks, almost concludes our work for the day. I see Steve's hot little hand up, and I'm wondering if you could review what still sits in front of us, and we can take sort of a poll about whether we have the mental energy to do that today. Go ahead, Steve.
So backing up just a bit on, so this stands at 5-5 right now. In anticipation of a minority report, has there been any thought from those members?
Assuming you're talking about us,
Yeah.
I'm not too fast.
Okay, that's what I thought. I just wanted to clarify that, pending the other votes that are absentee. So there are only, 3 more items that we were supposed to talk about today. The first one is you should have received a draft letter that serves as the committee's GEA report. I don't know if anybody had a chance to read that. It essentially sort of says MainePERS is operating within its statutory authority, but it raises some of the concerns that were just addressed in LD 1922 in terms of culture and employee and customer engagement. If the committee feels comfortable with that language and it's had a chance to review it, I'm happy to process that and we can sort of close the chapter on the GEA. I don't know how the committee feels.
Is there anyone opposed to that?
Okay.
Seeing none, go ahead, Steve, and send that forward.
Okay. The second item is a potential committee bill to implement the recommendations of the Basic Income Security. I had sent out a draft on behalf of Representative Sylvester. It's a draft bill that implements the recommendations from that report, which we had a presentation on earlier last month, and of which Representative Rader was a member and former Labor Committee member Senator Miramont was also on that committee. The way it works is if the committee wants to move forward with a committee bill, it can go in sort of 2 directions. So the first sort of more traditional and logistically easier way is that the committee can sort of take a vote on reporting out a bill. It's a little bit of sort of an informal motion. And if a majority feels that they want to go forward with the bill, it will be processed and turned into an LD, and then it will be referred back to this committee for a public hearing and work session in the normal fashion. That is one route that the committee can go if a majority of members feel comfortable advancing any sort of legislation based on those recommendations. The other, a little bit more complicated route is that the committee could decide to go forward with a committee bill and not have it be re-referred back to committee for deliberation and work in the usual manner. So the committee would take a formal vote to report out a bill And as long as there is a majority willing to do that, the motion would be ought to pass. And instead of coming back to the committee, it would go straight to the floor at that time. Now, having said that, if the committee still wants to go that route, it's possible to try to get permission to have a public hearing on an LR. But it's a little bit logistically challenging because the testimony portal is not set up for LRs, it's set up for LDs. So it would be sort of a little bit old-fashioned for those of you who've been around for a while. You remember you would submit your testimony via email to the clerk. You wouldn't have this fancy new portal to upload it to. And it does require permission from the presiding officers for that option to hold a public hearing on an LD or an LR, excuse me. So I wanted to lay that out. I had drafted this request on behalf of Representative Sylvester, and I don't know if the committee has any further thoughts. I'm happy to answer any questions on it as well.
I'll just say real quick that I think, the committee, the work of the committee, put this forward. This has been ongoing for quite a while. This was their recommendation, so I put it forward on their behalf. I think our colleagues and the folks who do this work, that we should have a hearing to see whether or not we think this is a good idea. It's generally what this committee likes to do. So I will just, let's try show of hands at first and see if anyone is opposed of putting out a bill that forwards the recommendations of this working committee. Is there anyone opposed? I see 1, 2. All right, let's go ahead and call the roll then. Mr. Purvis, if you would call the roll on this. Justin?
Yes, sorry, I have to get my sheet. Okay. Senator Daughtry is absent. Senator Guerin?
No.
No. All right, Senator Guerin is no. Senator Hickman?
Yay.
Senator Hickman is yay. Representative Sylvester?
Yay.
Representative Sylvester is yay. Representative Bradstreet?
No.
Representative Bradstreet is no. Representative Cuddy?
Yay.
Representative Cuddy is yay. Representative Drinkwater?
Nay.
Representative Drinkwater is nay. Representative Gear?
Yes.
Representative Gear is yes. Representative Morris?
No.
Representative Morris is no. Representative Pebworth?
Yes.
Representative Pebworth is yes. Representative Prescott?
No.
Representative Prescott is no. Representative Rader?
Yes.
Representative Rader is yes. Representative Warren?
Yes.
Representative Warren is yes. So we have 7 in favor, 5 and not in favor, 1 absent.
On the informal motion, that brings it forward to bring the majority having ruled to bring that forward as an LD. We'll get to hear the bill and we'll all get to vote on it again. So we look forward to that. Anything else, Steve?
Just one more item.
Hold on just a second, Steve. For folks who are raising their hand in the corner, this is a motion that we're not debating a bill. We're not, we don't have public testimony. So this was a sort of a committee only discussion about whether or not we were going forward with an LD. So we thank you for being here. And if you have comments, I'd love to hear them. If you'd email me, that'd be great. Or, my number is widely available. All right, Steve.
So the last item is, I do have a language review if the committee wants to do that today.
What's it on?
LD 775, which is the definition of public employee. So
let's hold that one off. That's fine. Yeah, let's hold that off. That's okay. Yep. And we'll do that on another day.
Okay, that's totally fine. I am happy to report that that was the last item of business that I have.
Perfect. All right. Thank you, everybody. Appreciate you. And, good bit of work today, sussing out the details of these bills. And let's keep that positive momentum moving forward. All right. Be well.
Thank you.